Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, this will be a video predominantly for the hometown crowd, but it could end up affecting many of you nationwide because this has to do with a current magazine ban being challenged and now petitioned before the United States Supreme Court. Washington, you guys geek out with this all the time. You know the drill. Whenever we're going to do a very infuriating video, we oftentimes say, hey, 3 fingers of bourbon, breathing exercises, or a barf bag. You're going to need one or maybe a combination of them. So today, let's spend a few minutes and let's talk about Washington's very dismissive response to your constitutional rights. Okay, America, and in particular the hometown crowd here at Washington State, we are talking about a challenge to Washington State's magazine ban now sitting before the United States Supreme Court in the matter of Gators Custom Guns versus State of Washington. In particular today, what we're going to be talking about is the State of Washington's reply brief. That is the brief that says that the Supreme Court should just summarily deny this petition. And Washington, let me remind you that Wally Wentz has put his entire livelihood on the line to be the tip of this spear. So if you want to help out the plaintiffs, and Wally in particular, we've linked up the Silent Majorities Foundation's link down below. Show them some love. Okay, we talk all the time. How are you going to frame the issue? Or as we like to call, what is the issue presented? Well, in what is going to be a brief all about distortion, because that's what the state of Washington attempts to do here, is just completely distort the issue. The state claims the issue presented to the court is whether the Washington Supreme Court erred in finding on the record before it that petitioners failed to show that large capacity magazines are arms within the meaning of the Second Amendment and failed to show that Washington's restrictions on large capacity magazines hinder the right to keep and bear arms. And you're going to see this theme weaved throughout this memorandum. It's all about the record, right? Because they never established that these are in common use for self-defense, although that would be an irrelevant finding. But to give you a flavor of how Washington is trying to frame this issue, they state the following. Large capacity magazines are firearm accessories used in virtually every mass shooting in recent memory. To prevent the proliferation of these deadly accessories and address the epidemic of mass shootings, Washington's legislature enacted Senate Bill 5078 restricting the manufacture and sale of LCMs in Washington. Gators Custom Guns and Walter Wentz, collectively Gators, opted not to challenge this law. Instead, they simply flouted it, indiscriminately selling thousands of unlawful LCMs. Yeah, see, it's not about the constitutionality of the statute. It's about what that dirty, rotten Wally Wentz did when he believed that the law was, in fact, unconstitutional. The state of Washington goes on to further plead. After they got caught, they argued for the first time that Washington's law violated the Second Amendment. They argued that Senate Bill 5078 is facially invalid and every one of its possible applications is unconstitutional. But they expressly declined to rely on expert testimony and failed to submit any admissible evidence. There it is, right there. It's all about the record. And so for those of you who sometimes are wondering, why are we out there trying to get sales data from companies? Because, of course, these things are in common use. Yes, that's like trying to prove that the sun sets in the west. But these courts, hell-bent on upholding these laws, will look for any way humanly possible to say, well, you just never established the factual predicate, therefore you don't have a claim. State of Washington goes on to say, ultimately, Gators' case went to the Washington State Supreme Court, and that court did what every other appellate court has done, rejected the plaintiff's Second Amendment challenge to LCM restrictions. And now, once again, they are doing what every other plaintiff has done, bringing a version of the same petition for certiorari that this court has denied 3 times in the past 2 years. The court should deny this petition as well. There it is. You know, the court has no interest in it because they have, in fact, rejected similar petitions. And we're seeing this repeated over and over and over, along with the fact that there's no circuit split. But ultimately, I want everyone in Washington to remember that your state Supreme Court had ruled that magazines are not arms and therefore are not even afforded any protection under the Second Amendment, a position that the state of Washington obviously vehemently believes in. Here again, the undisputed evidence showed that firing more than 10 times without reloading is useful on a battlefield, but virtually never done in self-defense. Lastly, the court recognized that even if LCMs are not themselves arms, they might still be protected if they were necessary to actualize the core right of armed self-defense. But where is that limit? That's the problem, right? And this is where we get to Barry Arrington's magic bullet theory about, well, apparently once we go past 10, the Second Amendment doesn't apply. So are we to assume that below 10, the Second Amendment does apply? And which one of our founding fathers actually established that? The state of Washington goes on to further claim, while there may be a point at which magazine capacity restrictions become so strict as to violate the Second Amendment, Gators failed to introduce any evidence that Washington's law approached, let alone crossed, the line. And you sit there and you go, well, wait a second, how could you even plausibly make that argument? You plausibly make that argument when you claim that pre-existing case law is all about proving in common use for self-defense. Now, this is something that the state of Washington got away with, not only in their pleadings, but candidly got away with in oral arguments. And I was a little dismayed that there wasn't as much pushback from the other side on that. Would it have made a difference? Probably not, but this is how the state of Washington sees things. The record in this case shows that LCMs are not commonly used in self-defense. Okay, and then just to give you an example, I went and totally geeked out on the Heller opinion. I did a word search, pulled out every single time common use was used. And as you can see through all of these quotations here, at no point does it ever limit common use to those that are in common use for self-defense. This is a completely fabricated legal argument that, again, the state of Washington, unfortunately, was allowed to get away with to some degree. In addition to all of that, one of the other arguments that the state of Washington makes is that, hey, listen, criminals are misusing these things. And since criminals are misusing these things, this gives the state the ability to ban them from all otherwise lawful and responsible gun owners as well. Translation, we don't trust them with guns, therefore we don't trust anybody with guns, all right? This is how they put it. While never needed for self-defense, large capacity magazines are routinely used and especially deadly in mass shootings, which is why the Washington State Legislature regulated them in Senate Bill 5078. Since 2010, 86% of all high fatality mass shootings have involved LCMs. Since 2020, 100% of all high fatality mass shootings have involved LCMs. And again, they just don't trust themselves with these weapons, so they can't trust you either, because this is how they put it. Because weapons equipped with LCMs are so much deadlier than other weapons, their use in mass shootings leads to a much higher casualty rates. The average number of shots fired in mass shootings where an LCM was not used was 16. By contrast, the average number of shots fired in a mass shooting where an LCM was used was 99. Okay, now listen, taking that logic of argument, because there are criminals out there abusing these constitutional rights, government then has the authority to strip people of these constitutional rights. Let's take a look at all the abuses going on currently in the voting system. Let's take a look at the abuses that are going on in the Washington state voting system right now, because we know for a fact that people are abusing that right. Does that then give government the right to strip those inalienable rights from their citizens? Because that's how gun control apparently works. But again, ultimately, where the state of Washington wants to just distort this or kind of play diversionary tactic, don't pay attention to the man behind the curtain, is it all comes down to the fact that they believe the record at the lower court was insufficient to prove what? That's right, that these magazines are in common use for self-defense, which again is not the rule of law, they claim. Thus, when the parties cross-moved for summary judgment, all of the admissible evidence supported the state's position. Nonetheless, in April 2024, the Superior Court issued an order finding SB 5078 facially unconstitutional under both the Washington Constitution and the Second Amendment. And then finally, the state of Washington concludes with all the other usual suspects that we've seen over and over and over in many of these other briefs in opposition to petition, including the following. The decision below faithfully applies this court's precedent. What precedent is that? LCMs are accessories, not arms. I want you to think about that. If that's the rule of law, what could possibly be banned? Where are the limitations on banning, right? Because they could literally ultimately end up banning all semi-automatic handguns. LCMs are not in common use for self-defense. While that's not true at all, it's also completely irrelevant because the rule of law is, are they in common use for any lawful purpose? And then, of course, finally, we get to this oldie but a goodie. There is no meaningful circuit split because every court of appeals to hear challenges to LCM restrictions has upheld them. Okay, so the case once again is Gators Custom Guns versus State of Washington. It is not currently scheduled for a conference. We just checked the docket today, but it ultimately will be scheduled for one, and we will keep you posted. Now, we're going to go ahead and link up the state's response brief down below. Washington, you know the drill. 3 fingers of bourbon, breathing exercises, or a barf bag. You're going to at least need one of them. All right, now listen, if you got any questions about this or anything else related to what's left of our Second Amendment rights, and if Washington gets it this way, there won't be much left in this state anymore. You guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information is down there in the description box. If you got an idea for a video we should be doing around here, you click on that link right there and you tell us all about it. If you want to subscribe to the monthly newsletter, that link is down there in the description box. And then finally, and most importantly, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching and stay safe.